the appellant, Willis Sheldon, is Thomas Costello. Seated at counsel table with Mr. Costello is Mr. Waite and Mr. Goodenow. Representing the appellee, Nicholas Ruggiero, is Ms. Haste. Seated at counsel table with Ms. Haste is Ms. Strimple.
Thank you. Counsel?
Mr. Chief Justice, members of the court, I would like to raise three issues. First is the facts of the case. The second is the case of Lachey, and the third is the march of the common law. Facts are important here. Dezirae was born in February of 2012. In February of 2013, she suffered two fractures. One, a comminuted fracture of her right tibia. And as we know, that's a crushing fracture that splits up the bones. The other fracture was on the left tibia. It was a spiral fracture. These were separated by 7 to 10 days. And the force involved in injuring this little girl in that fashion was massive and direct. 7 or 10 days later, she went to the hospital, and the mother, in due course, was substantiated for abuse of the child. She was charged with cruelty to a child, and she pled to not providing medical attention to the child in the summer of 2013. In the fall of 2013, Dezirae was returned to her mother in October, and the substantiation went to Major Ruggiero, retired Major Ruggiero, in October of 2013. And at that time, for the first time, it was a clear statement that as for these two horrible fractures, it was Doobie who did them. Ruggiero, retired detective, took it upon himself to go out and investigate because he knew, and in deposition indicated, how could they possibly put this child back into this home where Doobie and Eastman now were married. Eastman was carrying her third child. They were living together in Poultney, and this child was back in that home. So he went out and investigated, and he determined that there was no basis for it. And in fact, they got it right the first time, and there was never a determination of who inflicted these injuries, by DCF or anyone else. In January, the third child was born in the house. In February, Dezirae suffered bilateral fractures of the cranium, direct fractures of her little skull, and she suffered for 36 hours, and then she died. Secondly, Lachey is a case we submit is on all fours with this case here. The only difference was, in Lachey, it was Belove, who was the social worker, who was an employee of SRS. Here, Belove is former Detective Ruggiero. The reporter in that case was William Waite, who indicated that this boy, David Lachey, was sexually assaulted. In our case, is Sandra Eastman, who reported to Ruggiero that it was Doobie who broke the legs. In that case, it was Ricky Lee Rice, who was the assaulter of this little boy. In our case, it was Doobie who was the assaulter. The only difference is that Belove was an employee of the state. In this case, Ruggiero was not. So it went up on appeal, dismissed by the trial court. And at first they addressed Belove. And the court said, for Belove, it was a statutory duty under Section 4913 to report Mr. Waite's allegation. That was the sole cause of action against Belove. His offense was immunity. They overcame that immunity and overturned summary. Then they wanted SRS. In order for SRS to be liable, they had to prove the private analog. What was it? The action against Belove. Action against Belove, which was then pending, was the private analog that overcame the immunity against SRS. If there was no statutory cause of action, there was no private analog. There was no liability of Belove, and SRS would be immune.
Even if we conclude that there is a private right of action, and let's assume we accept your argument, the standard, as I see it, under 4913 is a mandated reporter who has reasonable cause to believe that any child has been abused or neglected shall report or cause a report to be made. How do we, a substantiation reviewer by definition is reviewing a scenario in which somebody has been charged with child abuse. Is your position that the reviewer has to file a report for every appeal saying, by the way, this person committed abuse? Or how does that get you under the statute?
Two ways. The court said, how do we? Well, first of all, we don't. Second of all, there's no duty to report unless there's a reasonable cause to believe. And a place where reasonable cause is determined is a jury. And the juries in our system that should be engaged in this problem, this horrific problem. And what the defense is trying to do here is to prevent the common law, as in the other case, from going and resolving and participating in resolution. The legislature said, this is a horrific problem in our society. It's horrific. It marvels any other ones. And the resources are engaged by the state's attorney to address it. The legislature, and then they said, you have to report this if you have a reasonable cause to believe. If you don't, common law, us lawyers, judges, the juries have to be engaged. And if they are engaged, they're going to do what the common law is built to do, to make a difference, as they have in DeRosa, in Kinnery, in Sabia. We are lawyers to do this. We didn't go to school or to clerk to do real estate all the time, or do contracts all the time. Most of us went there, as Maureen says about Bobby Three Stacks, to make a difference. And this is where lawyers and courts and juries can make it a horrific problem. And there's no issue about everyone being subjugated to it, as the trial court said. You have to be reasonable, and that's what juries are for. And we asked the court to reverse this, so we can go back to the Superior Court, try our case, have a jury determine if it was or was not reasonable, and whether or not these same kind of wounds, these crushing, bilateral crushing wounds to the skull, caused by Doobie. He's been convicted of that murder. Were also the cause of those same kind of wounds a year earlier. And if in fact they were, then he should have been removed from that house, and if Ruggiero had made that report, and there had been an investigation, which never was before, it would have happened, and that little girl would be alive today. Thank you.
Okay, thank you, counsel.
Good afternoon, and may it please the court.
Good afternoon.
I want to correct one thing first. Mr. Costello said the first time that Ms. Eastman accused or raised Mr. Doobie as a possibility as a perpetrator of the broken legs was during the administrative review conference with Mr. Ruggiero, but that's not true. If you review the record, you'll see that in the investigative report, there is a statement by Ms. Eastman alleging Mr. Doobie dropped Dezirae down the stairs. That was one of several inconsistent explanations she gave during the investigation, including that her sister may have been responsible, that she had dropped her in a pack and play, that their demons could have done it, that she didn't know what happened. And one of those explanations was Doobie. She repeated those explanations to Mr. Ruggiero in the administrative review conference, and Mr. Ruggiero included that statement in his written report that went to the commissioner. He determined that as a result of the investigation and his own meeting with Ms. Eastman, that she was responsible for the broken legs. Nothing he learned in the administrative review conference changed his mind, and so he upheld the substantiation. That's not what this case is about. And he made a report. Appellant contends the report was insufficient or didn't contain enough detail, but there's no dispute that the statement at issue about Mr. Doobie in the administrative review conference was communicated in writing to the commissioner.
What about the claim that your client undertook certain additional investigation that created a duty? Would you address that?
Absolutely. First off, that claim is duplicative of the underlying failure to report. What harm could there be of a so-called investigation other than it did not lead to an additional report? I think the Vermont Supreme Court's precedent on negligent undertaking is clear that there cannot be an undertaking without some kind of explicit promise or contract, and that is absent here. Mr. Ruggiero this entire claim is based on 2 perfunctory conversations.
But he had a contract with the state, right? It's in your papers.
That is correct.
There was a mandatory reporting requirement under that contract, very similar to the language in the statute, as I read it.
We do not dispute that Mr. Ruggiero is a mandatory reporter or that he had a duty to report.
Well, but what I'm asking, isn't it true he had this contractual duty as well, aside from the statutory duty?
The contractual duty is with the state. It's not with Dezirae or Mr. Sheldon.
But under the restatement, isn't the third party a beneficiary of this?
Whether the court considers that contract sufficient to constitute a contractual agreement, the conduct here, 2 conversations asking an investigator about her investigation and a social worker about her placement decision isn't an undertaking as a matter of law. Even if it were, none of the subsections in the restatement are met here. Murphy versus Century Insurance is clear that the conversations would have had to increase the risk of harm above would have been if he had done nothing. It's clear that simply failing to discover a danger, even negligently, is insufficient. And that's essentially the theory here raised by appellant, is that Mr. Ruggiero, in those conversations, only one of which even involves Doobie, failed to discover that Doobie was dangerous based on his conversation with Ms. Post, who also concluded that Ms. Eastman was responsible after she spoke to Mr. Doobie on the telephone during her investigation, and after reviewing the intake report in which Ms. Eastman blamed him at that time. So there's no evidence that Mr. Ruggiero's conversations increase the risk of harm to Dezirae, which is the requirement. And nor is there any evidence that Mr. Ruggiero undertook DCF's formal duty to investigate under the comprehensive statutory scheme, or that anyone relied on these conversations. I'd like to go back to the private right of action. This court's ordinary practice is to defer to the statutory remedy created by the legislature and to refuse to supplement it, particularly where it's clear the legislature could have done so, knew it could do so, and did not do so. The legislature created specific remedies, including a fine, and did include a private right of action against individuals who retaliate in an employment context against reporters. It's clear evidence that they understood they could create a private right of action in this context, but chose not to. And to recognize a private right of action here would impose significant liability on a wide variety of citizens in a wide variety of professions in a wide variety of circumstances: teachers, police officers, camp counselors, priests. The legislature had to balance the interests of children, and while that's an important interest, against these other actors and against the system, and designed the system the way that it did. And in the legislature made a clear choice, and the court's practice is to defer to that. Even the court in Shields v. Gerhardt made it clear that even if there is no remedy, there still a private right of action, even under those circumstances, isn't necessarily required.
How do we figure out, so the restatement sort of describes 3 scenarios. One is where you can tell from the legislation as a whole, or whatever information you have, that the legislature intended to exclude a private right of action. A second possibility is that the legislature intended to include a private right of action. And the third possibility is that the legislature just really had no intent either way on the issue. It wasn't within the legislature's contemplation either way. And it's in that scenario that the restatement then offers some guidance as to what to do. How do we get to where you are, which is that the legislature intended not to have this remedy, as opposed to the legislature just didn't address the issue either way?
Well, the intent of the legislature can be inferred from the entire statutory scheme, and particularly from the text of 4913 itself. I agree there's no explicit language, yes, private right of action, or no. But I think that the inclusion of one kind of private right of action but no other suggests that they were thinking of private right of actions when they were creating the statute. And importantly, when the statute was revised in 2015, in part in response to Dezirae Sheldon's death, the legislature could have made a variety of changes, including making the standard for reporting from reasonable cause to believe to reasonably suspects, making the standard less subjective in terms of what information to be included. If it, it balanced increased reporting with, it could have easily included a private right of action, but to make it absolutely clear if that was its intent. And sometimes we have to infer intent from silence.
Is it possible that they thought there was already a private right of action created in the Lachey case? We let it go forward after we remanded on the social worker because there were facts in dispute and summary judgment wasn't appropriate.
It's possible, but that would depend on the underlying conclusion that Lachey did create or did recognize an implied private right of action under the statute, which it did not. Here's why.
How come we let the case go forward?
Well, the only question the court was deciding was the issue of immunity. If any of the actors in the case had immunity, then certainly the case could not go forward. Mr. Belove did not dispute the plaintiff's legal theory, and the state, the discussion of the waiver of immunity that applied to the state is a different question. And the analysis of whether any party should or shouldn't have immunity is a different analysis than the restatement and the court's precedent requires in order to find an implied private right of action. While perhaps a related question, it didn't do this analysis, and the question of whether there's an implied private right of action is an open one. And the court should not recognize an implied private right of action for some of the reasons I've discussed. In Shields v. Gerhardt, the court made it clear that it will defer to the remedies chosen by the legislature, even if they're not as effective as money damages, because policy choices should be left to the legislature.
Did you have a chance to wade through any legislative history to discern whether this issue came up at all in the debates?
There's no evidence in the legislative history in the record that I'm aware of. I made some attempt to research this issue. The statute started out as a criminal statute and it had been revised several times. There isn't any of that in the record at this point. So I'll also briefly mention that the mandatory reporting statute is not a safety statute capable of supplying the standard of care in a negligence action. Dahmer makes it clear that the kinds of cases that fall under the restatement have been directly concerned with the safety of persons in the position of plaintiff to avoid the kind of harm that plaintiffs suffered. For example, a landlord can provide a safe exit for tenants, a driver can control the speed of her vehicle, a train operator can ring a bell or blow a whistle, and just because a statute protects children doesn't mean it's automatically a safety statute. Dahmer makes that clear. And since no one can have a duty to investigate and to report under the statutory scheme as Lachey recognized, Ruggiero was not in a position to investigate or to take any action to protect Dezirae himself. A reporter cannot control whether the report he or she makes actually stops the abuse. And in any event, Mr. Ruggiero did make a report. It's our position that he did not have a duty to make a report under the undisputed facts of this case because the statute requires reports of new abuse rather than new perpetrators. And even so, the broken legs had been substantiated. Eastman was found responsible. There's no dispute that Mr. Ruggiero reviewed the intake report or investigation records. There's no dispute that Eastman said Doobie dropped Dezirae down the stairs. And there's no dispute that the investigator had telephone contact with Mr. Doobie. In short, it's in the complaint, in fact, that Ms. Eastman gave multiple explanations during the investigation, which she repeated during her conversations with Mr. Ruggiero. In light of this, Ms. Eastman was not credible. And her inconsistent statements did not give rise to reasonable cause to believe that Mr. Doobie was the perpetrator of the broken legs as a matter of law. But even if it had, Mr. Appellant has conceded in the complaint in this case that DCF was aware of Eastman's statement in the report. That's paragraph 86 of the complaint, which is in the printed case. And Mr. Ruggiero's report complied with the statute. All the statute requires is a report in writing to the commissioner. And as well as in the complaint in appellant's brief, there's no dispute that the commissioner received the report or that it contained the statement that Eastman made blaming Mr. Doobie. To the extent any information was missing, it was not material. This case is based on Mr. Doobie and the potential danger he posed, not any of the other items appellant contends were missing or should have been included. And in any event, once a report is made in good faith, the report is entitled to immunity under the statute. And so I've already touched briefly on the negligent undertaking claim, and I'll just conclude by saying that the trial court's opinion was correct, that there is no private right of action nor is the mandatory reporting statute a safety statute. But even if there is some duty here, under the undisputed facts of this case, which are submitted for your consideration, there was no reasonable cause to believe that would have led to a report. And in any event, out of an abundance of caution, even though Ms. Eastman was not credible, Mr. Ruggiero made a report that did comply with the statute. And for all those reasons, we ask that you affirm the trial court's opinion. Thank you.
Thank you very much.
Appellant has 7 minutes and 40 seconds remaining.
Well, what difference did it really make whether he made his report as required or not? Difference was that this would have been a second report on this one victim, and that would have gone to the central office. It had never conducted investigation. It wouldn't have been Brown or Post. It would have been the central office in Montpelier, and they would have investigated the prior injuries, the nature of those prior injuries, and Doobie's involvement in it. And that investigation was significantly different than any investigation that occurred up until that time.
How do we, the statute talks about reporting abuse. It doesn't actually speak in terms of reporting additional evidence relative to abuse that has already been identified as being within the scope of the mandatory reporting statute. How do we deal with that?
I don't think that was an issue that Ruggiero had to parse out. If he became aware of this abuse, then he had the duty to report it. If he had reported it, then the investigation, which had never occurred, the investigation of the multiple breaks in the tibia. The prior was she fell down the stairs or he dropped her in a pack and play. That doesn't relate to the two fractures of both tibias, which resulted in the February 2013 injuries. And therefore, under the procedures at DCF, there would have been a thorough investigation of Doobie's involvement in the 2013 assaults, which had never taken place up to that time.
So wasn't your beef with DCF then? Because the purpose of the mandatory reporting statute is to alert DCF to a concern, and then it is DCF under the statute's requirement to conduct either an assessment or investigation, depending upon what type of report is made. So why should Mr. Ruggiero be faulted if DCF didn't conduct a thorough investigation at the time, when it knew that Mr. Doobie had potentially some involvement in this case?
The answer to the Justice's question, yes. DCF has responsibility here. Unlike in the Belove case, the two actions were separated. Under our law, more than one person or entity can be responsible. In fact, that's the case here. And under Spafford versus Howard or other cases, more than one person or entity can be responsible, and that was the case here.
Isn't your position advocating that a reporter is also responsible for the investigation if they have to report who might have done the act in question, as opposed to just, look, I think this act was done and that this child might have been abused or neglected? Aren't you adding an additional responsibility to the mandatory reporting statute?
No, Your Honor. We believe that the error here, the wrong, was not making the report. When there was a reasonable grounds to make it, and there's a basis for determining whether it was reasonable, and a jury should decide. Once that was made, that report was made, then it's a question of causation. And the plaintiff would have to prove at trial that, in fact, the failure to make that report did result, in this case, the death of Dezirae. And that would be a burden that the plaintiff would have to discharge at the trial.
What should that report have said? To the extent that there were a handful of different explanations offered in this interview about how the legs came to be broken, what would the report have said?
The report would say that the husband of Doobie now says that it was Doobie who broke the legs.
Or it was, I mean, she didn't only say that in that interview, right? Didn't she offer a host of different explanations?
Well, in the report, as I recall, she talked about it, but it was Doobie that broke the legs. And that was the new allegation. And that would have been the report to DC. Now it's indicative, and I think a jury should address this, that Ruggiero thought this was important enough to undertake this investigation going back to DC. He was that concerned. And that would be evidence the jury could consider about whether or not it was reasonable for him to make the report. We're simply saying the legislature intended not for Ruggiero to do that investigation, not for him to rule it out, but for him to make the report to DCF. And if it made the report, it would have made a difference in this little girl's life.
Doesn't count that he talked to Brown and Post about his concerns?
Did he talk? Yeah, I'm sorry.
It doesn't count that he talked to the investigator and the social worker, Brown and Post, about his concerns about Doobie?
Yes, it counts. It demonstrates that he knew that there should have been additional investigation, and the jury.
Why aren't you suing them?
Because, well, Your Honor, I think that they have responsibility also, and they are participants in the other lawsuit. And there's a statutory amount of their responsibility, and they paid the entire.
Right.
And I think it's so crucial that he went to both of them. He knew there was a problem here. He knew they were married. He knew they were in that house, and he went out there. But the jury's got to decide that reasonableness. And we submit that this was the last stop on that train. And if DCF had the chance to go and investigate, not what she did, but what Doobie did, then it would have made a difference. It was a new report, required of abuse, it required investigation, and if it had been done, the legislative intent would have been fulfilled. And we are asking you, in a real sense, she is asking you, to not stand in the way of common law lawyers to participate in juries in determining whether or not, or how this important policy should be promulgated. And she's simply asking you to give her the chance to take this matter forward as we normally would under the common law, and not to shield this actor who could have made a difference based on determinations which we think are proper for a jury. Thank you very much.
Okay, thank you very much.
That concludes today's hearing.